You see, it's not uncommon for Nigerian government officials and their relatives to enjoy state patronage. However, it is often kept discreet and managed by fronts, at least until the beneficial owners are out of office. In the case of OPL245, there were many unusual developments. Etete, as the Minister of Petroleum Resources, awarded OPL245 to Malabo in April 1998. General Abacha was the military head of state. And when Abacha died suddenly on June the 8th, 1998, the Nigerian political landscape changed dramatically. The Abachas lost power, and Etete became a former minister. As was later confirmed during court proceedings, Malabo had registered with disguised identities. In the original corporate registration documents, the shareholders were listed as follows: Mohammed Sani, 50%, Kweku Amafara, 30%, Wabi Hassan, 20%. Well, Mohammed Sani was in fact Mohammed Abacha. Kweku Amafara was, from all indications, Dan Etete. Wabi Hassan was a stand-in for Alhaji Adamu Hassan, then Nigeria's ambassador to the United States. In November 1998, Raskik Benige, Malabo's company secretary, issued a power of attorney to Etete, naming him as the company's consultant and empowering him to act on behalf of the company in all matters. Instructively, Benige wrote inter alia that Etete was authorized to transact, manage, carry on and do all and every business matter and things requisite and necessary, or in any manner connected with or having reference to the business and affairs of a company, and for such purposes to conduct all correspondence appertaining to such businesses and affairs. Well, this total surrender, so to say, sounded curious. It must be noted that Mohammed Abacha was detained in 1999 over the 1996 murder of Kudirat Abiola, wife of the late Bashir MKO Abiola, the winner of the annulled June 12, 1993 presidential election. Well, Abacha was released from detention in 2002, by which time OPL245 had been revoked and Etete had become the public face of Malabo as he started fighting for the license to be restored. Well, Etete himself denied owning Malabo, telling this day newspaper in an interview on August 31, 2002 that he did not buy anything in Malabo. In fact, he described himself as Malabo's consultant. But contrary to initial claims by Shell officials that he did not know Etete had an interest in Malabo, emails obtained by Global Witness and Finance uncovered in 2017 appeared to show that the companies dealt directly with Etete for at least a year before the OPL245 deal was finalized in April 2011. Mohammed Abacha alleged in court that Malabo's registration documents were altered without a board meeting, and his name was removed as a shareholder.
Malabo Oil and Gas was incorporated in 1998 to seek allocation of oil prospecting license with the Petroleum Ministry. OPL214 and OPL245 were subsequently granted to Malabo. At the time of granting the licenses, the shareholders were Mohammed Sani with 10 million shares, Kweku Amafega 6 million shares, and Wabi Hassan with 4 million shares. Kweku Amafega was a pseudonym of Chief Dan Etete, and Wabi Hassan was a pseudonym of Hassan Adamu. After the death of my father in June 1998, I was handed some documents and I was made aware of alterations and changes in Malabo. Subsequently, I gave a power of attorney to the late AVM Mukhtar Mohammed to kindly oversee the affairs of Malabo. He traveled to London to see Chief Dan Etete, who had fled the country then. It became impossible for him to see Etete. Subsequently, I sought the help of my lawyer, Abubakar Malami, who later became Attorney General of the Federation under President Buhari, to go to CAC and conduct a search. After some time, with no luck and response, I got Aro Atabo to conduct a search at CAC, and it was discovered that several alterations had already been done in June 1998 and November 1998, where my name was totally removed, and other changes in 2000, where shares which were altered and converted, and my name no longer appeared.
In 2011, when Malibu was negotiating to sell off its interest in OPL245 to Shell and Eni, well, Abacha said that he made every effort to warn the multinational oil companies regarding the outstanding shareholders dispute.
First step was to file a suit at Federal High Court, Abuja, seeking the courts to assert my ownership of the 10 million shares in Malibu. Then, I asked my lawyers in London to write Shell and Eni Agip, cautioning them against entering any agreement with Malibu, and I intimated them of being a director and a shareholder. It was a caveat to Shell and Agip. I got Aro Atabo to write a letter to the Netherlands and Italian embassy, the home embassies of Shell and Agip, to pass the information that the oil companies should not participate in any relationship with Malibu. Finally, I asked Atabo to publish in 2 newspapers, cautioning anyone and forbidding anyone from entering into any negotiations, event, or partnership with Malibu. Unfortunately, all fell on deaf ears.
Remarkably, Abacha told the courts that he did not pay for his shares in Malibu, which in itself could undermine his claim to ownership. Well, after Shell and Eni acquired OPL245 and Malibu was paid off, Abacha's lawyers wrote to Adoke asking him to help resolve the shareholders' dispute so that Abacha could get his share. Well, the letter was dated January the 20th, 2012, and Adoke, in his response, said Malibu was a private company on whose behalf the Attorney General of the Federation could not act. He advised that the directors should hold a meeting to resolve the issue, otherwise they should approach a court of law for judicial intervention. So on December the 18th, 2012, Abacha wrote to Adoke to inform him that he had nominated 2 lawyers to represent him at the dispute resolution meetings with other Malibu shareholders. Well, the Nigerian House of Representatives is also said to have looked into the dispute, reportedly at the instance of Abacha, but nothing came out of its report that the Block 245 resolution agreement be nullified. Well, Abacha clearly felt shortchanged, although many may raise moral issues as to how his father, as a head of state, would allocate an oil block to a company which he had interest. The same moral question would apply to Etete, who as a Minister of Petroleum Resources allocated the block to Malibu. But there was an issue of conflict of interest on both sides and a potential violation of a code of conduct law. Well, surprisingly, Obasanjo did not question the legality of Etete's ownership of Malibu while revoking the block in 2002. Also, Obasanjo did not raise any issue of a possible violation of a code of conduct law while agreeing to return the block through the 2006 settlement agreement. Well, with the settlement agreement, subsequent administrations recognized Etete as the owner of Malibu and dealt with him in that capacity. So while Malibu was enmeshed in controversies all over the world, General Danjuma was doing well with his OPL246. Sapetro, his company, entered into technical partnership with Total and Brass Oil to develop Block 246. Immediately it secured the prospecting license in 1998. Well, in April 2000, the companies discovered oil in 5 fields. And in 2005, the OPL was converted to an oil mining license, OML 130. And in June 2006, the China National Offshore Oil Corporation acquired 45% of OPL246 for $1.7 billion. Danjuma became one of the richest Nigerians and went on to establish his status as a philanthropist. Before President Muhammadu Buhari came to office in May 2015, the Malibu scandal had been mostly centered on the actions of the executives of Shell and Eni, as well as Etete. Adoke, who was the Attorney General of the Federation under Goodluck Jonathan, was mentioned mostly in passing. However, as soon as Buhari became president, the narrative changed dramatically and Adoke became the central figure. In fact, at a stage, the Nigerian government built its entire OPL245 case on the allegation that Adoke corruptly enriched himself. Oddly, the OPL245 transaction involved more than a dozen government officials under Presidents Obasanjo and Jonathan. In fact, the 2006 agreement was authorized by President Obasanjo and signed by Dr. Edmund Dalkoro, his Minister of State for Petroleum, and Chief Bayojo, his Attorney General of the Federation. The Block 245 resolution agreements were authorized by President Jonathan and signed by Adoke as Attorney General, Mrs. Dezani Madueke as the Minister of Petroleum Resources, and Mr. Olusegun Aganga as Minister of Finance. Well, the Category A signatories to the JP Morgan account from where transfers were made to Malabu were Dr. Yerima Lawan Ngama, who was the Minister of State for Finance, and Mr. Danladi Kifasi, the Permanent Secretary of the Federal Ministry of Finance. The Category B signatories were Mr. Otunla Jonah Oguneyi, then Accountant General of the Federation, and Alhaji Babayo Shehu, who was then Director of Funds in the Office of the Accountant General of the Federation. But Adoke was the only former government official charged to court by the Buhari administration. Now, Nigeria's lawyers tried to build a case of corruption around Adoke, so his name was mentioned prominently in the court cases in Italy and the UK. So how did Adoke become the poster boy? Well, till date, only Adoke has extensively told his own side of the OPL245 story. In 2019, he published a book, Burden of Service, chronicling his time in office as the Attorney General. And in that book, Adoke stopped short of saying Buhari sent the EFCC after him to sort of exact revenge for Mohammed Abacha for reasons best known to him. Recall that Abacha had sought Adoke's intervention in Malabu shareholders' dispute after payments were made for Block 245 by Shell and Eni. Well, Adoke said he turned him down because it was outside the scope of the functions of the Attorney General of the Federation. Adoke wrote,
President Buhari was misled into thinking that I was not fair to the Abacha family in the Malabu transaction. That Mohammed Abacha suddenly began to grow in confidence under the Buhari government is not in doubt.
Incidentally, Abacha was the EFCC's star witness in the criminal trial of Adoke and others at the FCT High Court Abuja. In fact, Abacha attended court hearings throughout. Although it should be noted that neither he nor the other EFCC witnesses accused Adoke of committing the forgery of Malabu's documents, but really was the EFCC fighting for Abacha. In October 2022, Mr. Abdurrashid Bawa, the then EFCC chairman, wrote to the Attorney General, Mr. Abubakar Malami, asking that Eni should set aside $500 million to compensate Mohammed Abacha if the case against Adoke and the oil companies were to be discontinued. Now, when President Bola Tinubu assumed office and removed Bawa, he appointed Mr. Abdulkarim Chukul as the acting chairman. Weeks after assuming office, Mr. Chukul also wrote to Tinubu in a letter dated August 25, 2023, asking that the federal government should enter into negotiations with Shell and Eni to compensate Abacha and Pecos Energy, whom he described as the real owners of Malabu. While AFCC's sustained advocacy for Abacha tends to lend credence to Adoke's allegations against the commission. Adoke was on self-exile in Ghana for most of Buhari's first term in office between 2015 and 2019. The EFCC conducted a number of raids on his houses in Kano and Kogi State, but reportedly did not find anything incriminating. In fact, in April 2019, the EFCC secured a warrant of arrest against him. Although the warrant of arrest was set aside by the court in October 2019, Nigeria did not withdraw the red notice it had sent to Interpol. Now, fast forward to November the 12th, 2019, Adoke was arrested by Interpol in Dubai, the United Arab Emirates, and detained for 35 days. On his return to Nigeria, he was arrested and detained for 55 days by the EFCC, during which he was charged to 2 different courts. But the major allegation filed against Adoke by the EFCC was that he collected a gratification of 300 million naira for his role in the Block 245 resolution agreement. He was said to have collected the gratification in 2013, 2 years after the agreements were signed. Well, the EFCC alleged that Alhaji Abubakar Aliyu, the property developer who was accused of distributing bribes in the OPL245 deals, paid bribes into Adoke's account at Unity Bank. In the burden of service, Adoke denied receiving any bribe from the OPL245 transaction, maintaining that the particulars of the loan he took from Unity Bank PLC in 2012 to buy property from Aliyu were manipulated by the EFCC to create the impression that it was gratification. Adoke said he had been approached in 2012 by Aliyu with regards to an Abuja property valued at 500 million naira. But he said he got a loan of 300 million naira from Unity Bank, while his equity contribution was to be 200 million naira. The loan was approved and transferred to Carlin International, which is Aliyu's company. However, when Adoke failed to pay up his 200 million naira equity, which he blamed on his inability to find a buyer for the land he wanted to sell to raise the money, Aliyu refunded the 300 million naira to Unity Bank in 2013 and retrieved the title deeds. Aliyu then sold the property located at plot 3271 Cadastral Zone AO6, Maitama District, Abuja, to the CBN. Till date, the CBN owns that property. The EFCC argument was that the money refunded to the bank in 2013 by Aliyu was a bribe in disguise. Before and during Adoke's criminal trial, several developments had appeared to weaken the EFCC's cases against him. In a letter dated September 15, 2017, Mr. Abubakar Malami, the Attorney General of the Federation, wrote to President Buhari on the court case, arguing thus:
The EFCC investigation and attached proof of evidence do not appear to have clearly revealed the case of fraud against the parties who claim to have acted in their official capacities with the approval of 3 consecutive presidents of the federal government of Nigeria, at the time with further claim that the matter was intended to be resolved in national interest, thereby saving the nation acrimonious litigations resulting in high legal fees and the dormancy of the oil field while litigation lasted.
Malami also wrote to Mr. Ibrahim Magu, the EFCC acting chairman, on September 20, 2017 to state the legal basis on which the proposed criminal charge over OPL245 should be dropped. On December 13, 2017, Dr. Ibe Kachiku, as a Minister of State for Petroleum Resources, also wrote to Buhari through the Chief of Staff, Malam Abba Kyari, asking the federal government to abide by the 2006 settlement agreement. And on February 6, 2023, Malami wrote to Buhari again, admitting that Nigeria could not win the court cases on OPL245 and asking that the proceedings be terminated so that the oil block could start production in the interest of the Nigerian economy. Now, regarding the court proceedings referred to by Malami, things did not go well for Nigeria in the decided cases, and things were not looking too good for the ongoing cases. In the Court of Milan, one of the defendants, Mr. Vincenzo Armana, a former Eni manager, testified on July 17, 2019 that Adoke threatened to arrest and jail officials discussing kickbacks during the transaction with Malibu in 2011. In Nigeria, a major setback in the EFCC case emerged during the trials. The prosecution witnesses did not make incriminating statements against Adoke. Some did not even mention Adoke's name at all. In the case before Justice Abubakar Idris Kutigi of the FCT High Court, Mr. Ibrahim Ahmed, who was the EFCC prosecution witness, said the 300 million naira deposited into Adoke's Unity Bank's account was a bribe from Aliyu. But in the money laundering case before Justice Enyangeko of the Federal High Court, the same EFCC prosecution witness said that the 300 million naira was the repayment of the loan which Adoke took from the bank. Ahmed also confirmed that Adoke did not take possession of the property and that it was sold to the CBN. Aliyu, meanwhile, had told Justice Eko that the EFCC asked him to lie that he gave Adoke a bribe of $20 million. This, Aliyu said, was for him to regain his freedom from detention and be used as a prosecution witness instead. He alleged intimidation by the EFCC team led by Mr. Balasanga to make him implicate Adoke and Jonathan. Mr. Rislanuddin Mohammed was a former acting Unity Bank MD who stood as the EFCC key witness, also told Justice Eko that the 300 million naira was a loan the bank gave to Adoke and that there was no money laundering involved in the cash repayment. Clearly, the entire Malabu saga turned out to be a monumental waste of time and resources for everyone concerned. Nigerian anti-corruption campaigners suffered a litany of setbacks and losses in their attempts to prove that there was a fraud. Every single court of law determined that there was no evidence that fraud was committed in the Block 245 resolution agreement. The losses started in the US, where the Department of Justice and Securities and Exchange Commission investigated the petitions by Recommon, the Corner House, and the Global Witness, and closed the inquiries without bringing any charges against Shell, Eni, and others. And on May the 22nd, 2020, a UK commercial court declined jurisdiction in a case Nigeria filed against Shell and Eni. But the biggest blow was the criminal trial at the Court of Milan, Italy, which had drawn global attention, where it was tagged by the NGOs as the world's biggest corporate corruption trial. But after 3 years of trial and 74 hearings, the Court of Milan discharged and acquitted Shell, Eni, Tete, and other defendants of the corruption charge on March the 17th, 2021. The Honorable Justice Marco Tremolada, the presiding judge who read the judgment, declared thus:
This court acquits the 15 defendants of the criminal charges brought against them and reported in the court of indictment because it has not been proven that an offense was committed, and consequently dismisses all of the demands proposed regarding criminal matters.
On July the 17th, 2022, Celestina Gravina, the Italian Attorney General, terminated the appeal in the trial of Shell and others. It essentially said that the case has no basis. In fact, it should have finished earlier. So fast track to June the 14th, 2022, Nigeria also lost the $1.7 billion Queen's Care claim which it filed against JP Morgan Bank over the transfer of Block 245 sale proceeds to Malabu.
Was I satisfied that 1. Mr. Adoke caused the payment instructions, and 2. Mr. Adoke was receiving monies by way of bribe? I should certainly have concluded that it was a fair inference that he had caused the payment instructions in pursuance of such an agreement. However, since I have concluded that he did not cause the payment instructions, and that on the balance of probabilities he was not bribed, the point is purely contingent.
There were several court proceedings in Nigeria as well. In 2020, the EFCC charged Adoke, Aliyu, Benige, Malabu, Ajib, Shell Ultra Deep, and Shell Nigeria Exploration before the FCT High Court. The FCC alleged money laundering, violation of public policy, and illegal alteration of Malabu's company registration document. But in another blow, the FCT High Court on March 28, 2023, upheld the no-case submission of the defendants and dismissed the charge. In fact, Justice Abubakar Idris Kutigi declared, mere allegations, no matter how weighty, do not translate to or are tantamount to fact and evidence. And finally, on April the 19th, 2024, Justice Eko of the Federal High Court delivered his ruling in the separate case of money laundering against Adoke and Aliyu. Although there was no mention of OPL245 or Malabu in this case, it was the same particulars before Justice Kutigi that the EFCC charged before Justice Eko, and in upholding Adoke's no-case submission as well as discharging and acquitting the former minister, Justice Eko, however, ruled that Aliyu had a case to answer in the other counts filed against him in which Adoke was not mentioned. Notably, the EFCC did not appeal the rulings of the FCC High Court and the Federal High Court that discharged and acquitted Adoke. Well, the OPL245 story never really comes to an end, does it? Because on October the 8th, 2024, an Italian court jailed the prosecutors for hiding vital evidence during the trial of Shell and 14 other defendants by the Court of Milan. Fabio De Pascal and Sergio Spadaro were the two prosecutors were sentenced to 8 months in prison by Brescia Court for not disclosing documents that could have vindicated the defendants. Adoke, though not on trial in Italy, had earlier written to complain to the Court of Milan that the prosecutors were hiding evidence that showed that the Abuja property linked to him, which was described as a bribe from the OPL245 deal, actually belonged to the Central Bank of Nigeria. Adoke also complained to the Nigerian police that an email was forged and an interview with an imposter was stage-managed to implicate him in the court cases. Well, the police investigated and charged Mr. Olariwaju Suraju, the frontline Nigerian anti-corruption campaigner and chairman of Heather Resource Center, to court for allegedly circulating the materials on social media. Heather was, by the way, the Nigerian partner of the international NGOs that brought the Malabugate case to global attention. You remember? Well, the court cases against Suraju was eventually terminated by the government before the trial could start. For now, can we conclude that the long-running OPL245 soap opera, which started unnoticed in 1998 and went on to acquire global fame, has ended? With all the major court cases concluded and the Italian prosecutors jailed, and with the Nigerian government given the go-ahead to develop the oil block, can we finally say we have seen the last episode of the OPL saga? But don't bet on it, because with OPL245, it is never fully over.